You're driving home, backpack sitting on the passenger seat, when you see the lights flash behind you. Your heart drops a little. You pull over, and as the officer walks up to your window, you glance at that backpack and think, can they actually search that? Right now, without asking, without a warrant? What happens next might surprise you, because the answer isn't what most people assume. Here's the first thing that catches people off guard. The police cannot search your backpack just because they pulled you over. A traffic stop, by itself, gives them zero authority to go digging through your bag. That's not a guess. That's the Fourth Amendment talking, the part of the Constitution that protects you against unreasonable searches and seizures. But if that's true, then why do so many people believe the opposite? Why does it feel like once the lights are on, your rights disappear? Let's back up for a second, because to really understand this, you need to understand what the Fourth Amendment actually promises you. It says the government needs a warrant, backed by probable cause, before they can search your personal property. Your backpack counts. Courts have long treated bags, purses, and containers as places where you have what's called a reasonable expectation of privacy. That phrase matters a lot, and we'll come back to it because it's the key that unlocks almost every question people have about this topic. Now, here's where it gets interesting, because there are exceptions to the warrant requirement, and this is exactly where confusion and sometimes fear creeps in. The Supreme Court has carved out specific situations where officers don't need a warrant, and once you know what they are, you'll never look at a traffic stop the same way again. The first exception is consent. If you say yes, if you tell the officer, sure, go ahead, you've just given up your Fourth Amendment protection for that search. No warrant needed. That's why officers often ask, almost casually, mind if I take a look in your bag? It sounds like a friendly question. Legally, it's an invitation for you to hand over a right you didn't have to give away. And here's something a lot of people don't realize. You are allowed to say no, calmly, respectfully. I don't consent to searches is a complete sentence, and using it does not mean you're guilty of anything. But what if you don't consent, and the officer searches anyway? This is where the second exception comes in, and it's the one that trips people up the most. It's called probable cause. If an officer has specific, articulable facts that suggest evidence of a crime is inside that backpack, they may be able to search it without your permission and without a warrant. Maybe they smell something illegal. Maybe they see contraband in plain view through an open zipper. Probable cause isn't a hunch, and it isn't a feeling. Courts require more than suspicion. They require facts that would lead a reasonable person to believe a crime is happening. So now you're probably wondering, what happens if you're in a car and get arrested? Does that change everything? It does. And this is where one of the most important Supreme Court cases in modern search law comes into play. In 2009, the court decided Arizona versus Gant, a case that reshaped how officers can search vehicles incident to arrest. Before Gant, police had wide latitude to search a car and anything inside it after an arrest. But the court tightened that dramatically. Now, officers can only search the vehicle without a warrant if the arrestee is within reaching distance of the passenger compartment during the search, or if it's reasonable to believe the vehicle contains evidence related to the crime of arrest. That second part matters enormously for backpacks, because if you're arrested for, say, a suspended license, there's no obvious connection between that offense and the contents of your bag, which means, in many cases, that backpacks should remain off limits. But let's slow down here, because reality often gets more complicated than theory. What if the backpack isn't in the car at all? What if you're walking down the street and an officer stops you? This is where a different legal standard kicks in, something called a Terry stop, named after the 1968 case Terry versus Ohio. That case allows officers to briefly detain someone if they have reasonable suspicion of criminal activity, a lower bar than probable cause. During a Terry stop, an officer may conduct a limited pat-down of your outer clothing if they reasonably believe you're armed and dangerous. But here's the critical distinction people miss. A pat down for weapons is not the same as searching the inside of your backpack. Courts have generally held that officers need more than just the authority for a brief stop to start unzipping bags and rifling through contents. Now you might be thinking, okay, but what about school? What about the mall? Does this apply everywhere the same way? And this is where things shift again, because your rights during a traffic stop are not identical to your rights in other environments. In public schools, for example, the standard is different. In the 1985 case, New Jersey versus TLO, the Supreme Court ruled that school officials only need reasonable suspicion, not the higher probable cause standard, to search a student's belongings, including backpacks. That's because courts have recognized a different balance of interests inside a school building, weighing student safety and the educational environment differently than they would a public street. And what about airports? This is where people often assume all their rights vanish completely, but that's not quite accurate either. At airport security checkpoints, the TSA operates under what's called an administrative search exception, designed specifically to prevent weapons and explosives from getting onto planes. You can typically decline additional screening by choosing not to fly, but once you're in the screening process, your backpack can be searched as part of that safety process, separate entirely from ordinary criminal search law. So we've covered consent, we've covered probable cause, we've covered the Terry stop distinction, we've covered vehicles, schools, and airports. But there's one more piece that ties this whole picture together, something most people have never even heard of: the plain view doctrine. If an officer is lawfully standing somewhere and they see contraband in plain sight, no digging, no searching required, that observation alone can justify further action. This is why leaving something visible through a car window or an unzipped bag flap can change the entire legal calculus in seconds, even if the officer never touches your backpack directly. Let's bring this back to a real, grounded scenario, because legal theory only matters if you understand how it plays out in your daily life. Imagine you're pulled over for a broken taillight. The officer walks up, asks for your license and registration, and then says, "What's in the backpack?" Nervous energy is completely normal here, even if you've done absolutely nothing wrong. But your response matters. You are allowed to stay calm, hand over your documents, and simply state that you don't consent to a search of your belongings. This isn't defiance. This isn't obstruction. It's the respectful exercise of a constitutional right that the Supreme Court has protected for decades. Here's the misconception that gets so many people in trouble, though. Not legally, but psychologically. Many people believe that refusing consent makes them look guilty, so they say yes to a search just to seem cooperative. But cooperation and consent are two completely different things. You can be polite, respectful, and fully cooperative with an officer's lawful instructions while still declining consent to a search. Judges have repeatedly emphasized that invoking a constitutional right cannot be treated as evidence of guilt. Choosing to protect your rights is not suspicious. It's simply smart. Now here's a twist that catches almost everyone off guard. What if the officer searches your backpack anyway, without consent, without probable cause, and without a warrant? Does that mean the search was automatically illegal? Legally, yes, it likely violates the Fourth Amendment. But here's the part few people expect: that illegality doesn't get resolved on the roadside. It gets resolved in court. If evidence is found through an unlawful search, your attorney can file what's called a motion to suppress, asking the court to exclude that evidence because it was obtained illegally. This is where the exclusionary rule comes in, a doctrine established through cases like Mapp versus Ohio in 1961, which held that evidence obtained through unconstitutional searches generally cannot be used in a state criminal prosecution. It doesn't undo the search. It doesn't erase the moment, but it can determine whether that evidence ever sees the inside of a courtroom. This is exactly why legal experts consistently advise the same approach during any encounter with law enforcement. Never physically resist a search. even one you believe is unlawful. Instead, state clearly and calmly that you do not consent and let any legal issues be resolved afterward through the courts, not through confrontation on the street. Your safety in the moment always outweighs winning an argument about constitutional law with someone holding a badge and, in many cases, a firearm. So let's tie this all together, because by now the picture should be much clearer than it was at the start. Police generally need a warrant to search your backpack. Consent removes that requirement instantly. Probable cause can eliminate it too, especially when evidence is in plain view or clearly detectable through the senses. Arrest can open the door to vehicle searches, but Gant narrowed exactly when that applies. Terry stops allow pat-downs, not full searches, of your belongings. An environment changes everything. Schools, airports, and public streets all operate under different constitutional standards. If there's one thing to remember above everything else, it's this. Silence and calm refusal are not admissions of guilt. They are the exercise of a right that generations of court decisions have worked to protect. The Fourth Amendment doesn't disappear because someone is wearing a uniform. It bends under specific, legally defined circumstances. And understanding those circumstances is what separates confusion from confidence the next time flashing lights appear in your rearview mirror. If this raised questions about what happens when police want to search your car itself, not just what's inside it, that video is exactly where we're headed next, because the rules there are just as surprising and just as important to know before you ever find yourself living through it.